of the state against Zachariah Anderson. And appearances, please.
Jessica Krzarek and Mike Gravely from the District Attorney's Office.
Good afternoon, Your Honor. Attorney Nicole Muller appearing for and with the defendant, Mr. Zachariah Anderson.
All right, and let me just take a moment. There's quite a few spectators here, and I understand why people have strong feelings about this case, and that ordinarily doesn't present any problem. Occasionally, people feel the need to express some of their sentiments here in court. That is not acceptable. That's why we don't permit badges and insignia and special clothing and that type of thing. And also why there'll be limitations on the people who will be permitted to speak. Some of them have a statutory entitlement to speak. And there are a few instances others will be permitted to speak, but not everyone who wishes to speak will be allowed to do so. I also was just handed within the last 10 minutes 4 or 5 letters that I scanned. I did not read them carefully, and they were provided by the defense. I've never utilized these types of letters extensively. Some letters come in as victim statements, which have a legal classification, and are received and presented to the court according to law. Some of them are remarks which were gathered by the writer of the pre-sentence, and I do pay attention to those, although the decision is mine and not what people encourage me to do. But as a general statement, the character reference type letters written by acquaintances of the defendant have generally, in my experience, not been helpful. And I've discussed this with colleagues of mine at the judges' conferences, and I'm not alone in my views. And some of the problems are, number one, they're censored. That is to say, they're not going to be generally negative towards the defendant, or they wouldn't be handed up to me by the defense. And number two, many of them recount incidents that really are not significant, certainly not significant in the context of the enormity of this case. But I did take a look at them briefly. There can be no usage of telephones or iPads or anything like that during the hearing except the media who have been approved. So if you're using your phone, if your phone is out of your pocket, the deputies will collect it from you, and you will not get it back instantly if you get it back at all. So please keep that in mind. No phones, no calls. Phones must be silenced. I understand it's very difficult not to react, but you must enforce. You were wonderful at the trial, you who were here. So please continue with that, and no reactions in any way. Those who are allowed to speak, keep in mind that you're allowed to speak. The reason you're allowed to speak under the law is to attempt to influence my decision. The decision in this case that the jury made turned the case over to me to make the legal decision as to what the ultimate outcome of the case will be. And you're allowed to give me your thoughts on what ought to be done. I do not permit, and you see this on TV by judges who either haven't had a lot of experience or who consider it acceptable. This is not a therapeutic purpose where people can vent at Mr. Anderson. He has to pay the price for what he's done. And that is my function here. And I will certainly consider what those who are permitted to speak will say. But this is not an opportunity to speak directly to him or to condemn him or ridicule him or anything like that. It's limited to making remarks to me as to what you think should happen. And there are no restraints in terms of what in the legal limit, what the statutes provide as what can happen as a result of the case. So obviously, I'm not. I'll cut you off if you are recommending the death penalty or something like that, because I couldn't do that if I wanted to. So just keep that in mind, please, and no direct assaults on either him or his attorneys, and or any of the witnesses. And does anyone have any questions? And you will not be permitted to go in and out. If you're expecting a phone call or something, I'm not going to say you won't be permitted, but if it becomes any kind of a problem, I'll simply instruct the officers that no one will be permitted to go in or out. So keep that in mind if you're awaiting a phone call right now, that if you leave, you may not be permitted to return.
Judge, we believe one of our speakers may wish to leave after they finish. That certainly is permitted, correct?
Yes.
Okay, thank you.
Any questions, anybody? All right. The information charges not only that the defendant committed the crimes of stalking as to the first and second counts of the information, intentional homicide of the first degree in the third count of the information, and hiding a corpse in the fourth count of the information. The jury found him guilty as to each of those charges. It alleged also that he was a repeater because he had been convicted previously of a felony crime. And is that in dispute?
No, Judge.
Mr. Anderson, it is, well, why don't you identify the felony so I'm...
It's possession of marijuana more than 10 pounds out of South Dakota, was convicted April 16th, 2020, which was about a month before this homicide.
All right. Is that a correct statement, Mr. Anderson?
Yes.
I have to actually obtain it from him directly. If he's not, then the district attorney will have to present the certified judgment of conviction.
Actually, Judge,
I don't.
by case law, we're permitted to use the pre-sentence as actual basis.
You can. You're right. That is an acceptable secondary source. You don't have a judgment?
I do, but it's back in my office in the boxes of materials, and because I was...
In the meantime, I think he did concede the fact of the former conviction.
I don't specifically remember what dates, but yes, I believe that's accurate.
All right. The state alleges that you are an habitual offender because you had been convicted of the felony offense of possession of over 10 pounds of marijuana at Butte County, South Dakota on the 16th of April of 2020, with sentence to be imposed on the 27th of May of 2020, which I don't think has yet occurred. Is that an accurate statement?
No, he was sentenced in December of 2021 in the South Dakota matter.
I did read that in the pre-sentence. So is that accurate?
Yeah, Judge, it is.
Okay, thank you. All right. Anything further before the state makes its presentation?
No, thank you.
All right. Now, do you want to speak before or after any persons who would qualify?
I will speak after the victim's family speaks.
All right.
Judge, before the state presents its position and the family speaks, there were several corrections to the PSI that the defense wanted to note. I don't know if the court would like to do that now or
Yes,
later.
and I'm glad you brought it up. Thank you.
To that point, Judge, there had been a filing by the defense to adjourn this hearing due to the fact that we did not have time to be able to go over the PSI as required by law with Mr. Anderson. We were able to do that before this hearing started this afternoon. In reviewing the PSI, there were sections that I reviewed for the description of the offense, the factual section. I reviewed that on my own and found that there were several errors as far as what was actual evidence in this case. There were two. On page 3 of the PSI, I think that there was descriptions of how the altercation occurred between Mr. Anderson and Mr. Gutierrez. Basically, that the struggle began at the doorway to the apartment. I did not think that that was supported by the evidence in the case. Additionally, that there was, on page 3, there was also descriptions of how the blood pool in the living room got there, and I also think that was inconsistent with the evidence in the case and the testimony in the case. But as far as an actual, so that's more of just an evidentiary versus what came in, did not come in. But there was a complete error of fact on page 9, which says that in the car, when it was searched, there were 2 opened but uneaten cans of sardines. Those sardine cans were not opened. They're bizarre. It's a clear top sardine, so that it looks opened, but it's not. That was confirmed by reviewing the actual sardine cans that were recovered. Seems like a small detail, but if it's going in a PSI, I want to make sure it's accurate, Judge. So that was on page 9. Additionally, on page 8, previously, there were things that were not in evidence, were not established to any degree of certainty. That being the burned remnant. This is in the 6th paragraph down. The sentence, the burned remnant of fabric located there matched the color and pattern of a shirt that was frequently worn by the defendant. The defense would challenge that as fact. And then also the information regarding Agent Hemmerl of the DCI, he did not provide testimony, and we would refute that as being factual at this time. Those were the corrections from the description of the offense, Judge, that the defense wanted to note on the record. As far as the things relating to what Mr. Anderson told the PSI writer, there were several corrections. I'm going to go in numeric order so that the state can follow along. On page 9 of the PSI, where it starts the defendant's version, the defendant informed myself that he did not say that the criminal complaint was completely wrong, that there are portions in there that are accurate, so that reliance is not what Mr. Anderson had told the PSI writer. Additionally, there's a sentence that Mr. Anderson said he was not jealous of any relationship Ms. Beecham might have been in. That's also inaccurate. Mr. Anderson said he told the PSI writer that he did have some jealousy, and that was also admitted to when police had received a statement from Mr. Anderson on May 19th, 2020. Next page would be page 16. I do just want to note on page 16 that there is a juvenile record for the one that says the date of offense 6/20, the disorderly conduct. Obviously, the court knows this, but counseled and closed means that there was not a finding of delinquency in that case, so it's not technically a conviction to be considered for a juvenile record. So I just wanted to reiterate that we wouldn't be considering that to be part of the record. Page 17, the first paragraph, when asked about the 1994 disorderly conduct, which was that juvenile record that was counseled and closed, that there was not that delinquency finding, that this reliance where it says the defendant remembers this differently, that is not relating to the 1994 situation. The defendant had explained to the PSI writer that all he could remember was an incident on his 18th birthday. So this was, the defendant remembers this differently. That whole paragraph, what he's describing is something that occurred on his 18th birthday, which would have been in 1998, not 1994. And then also on page 17, it talks about how the next paragraph, that Mr. Anderson had entered a garage and helped a person steal a stereo equipment. That's not what he informed the PSI writer. What he informed the PSI writer was that he knew the individual who had entered into his neighbor's garage. He knew that that person had taken that equipment. That is what he told the PSI writer, and that's what he had said back in 1994. Also down to, I guess, the second to last paragraph, even though the last paragraph on page 17 is only one line, but it talks about a sexual assault of a child where there was sexual intercourse which was non-consensual. Mr. Anderson said he had never reviewed that PSI from the 1995 incident, that it was consensual. From looking at the records, it appears also that it was an incident where he was 15 and she was 15. They were dating. So it was two children. But basically the objection is to the non-consensual language, that the defense maintains that it was consensual. Moving to page 24, the PSI writer noted that Mr. Anderson had been bullied in school. That's not what he remembers saying to the PSI writer. He maintains he was not, the defense maintains that he was not bullied, but rather he was just new to the school. On page 26, there's a line that says, the defendant feels that the present event is the most traumatic experience in his life. The defense maintains that was not stated by the defendant. And then there's on page 28, when talking about use of controlled substance, specifically mushrooms, the second sentence says, for him, this is a ritualistic use. It should read, for him, this is not a ritualistic use. And then also that second statement was taken out of context, and we'd ask that that was not what Mr. Anderson stated to the PSI writer. Judge, sorry, that was a little lengthy, but I wanted to make sure I was doing my diligent work in ensuring that we made a record of the corrections that we felt necessary of the PSI, but that is all we had. I don't know if the state had any corrections to add.
First off, do you want to dispute any of what has been claimed by the defense?
Judge, I think a lot of that is just argument in and of itself, so I don't think we need to respond to it in this way. I think it's something we can clear up during our comments.
Well, I half agree with you. I ordinarily say if it's not going to have any effect on the outcome of the case, then I'm not going to have any finding. So we don't need to go through the ritualistic presentation of the state on each point. Certainly the whether or not the sexual incident from age 15 was non-consensual would be a significant issue in a large number of cases, but in this particular case, I don't think that I would attach a great deal of significance to it, given the enormity of the crimes involved here. And so I'm not, unless you have that information readily at hand as to whether that was clearly part of the finding by the juvenile court, I'm not going to make any finding on that one.
My understanding on that is that the complaining witness or victim back in 1994 indicated it was not consensual, so that's how it was charged out. Whether he viewed it as consensual, I obviously do not know, but the complaint to law enforcement was for a non-consensual sexual encounter.
That was what I understood, but I did not conclude that what the outcome of the case was a determination that there had in fact been a non-consensual event. So I'm not going to make any finding that would have any significance with respect to the outcome of the case. Anything you have with respect to content of the pre-sentence?
No, there are generally some typos, but nothing that is worth bringing to the court's attention.
Thank you. All right, and let me invite you to proceed with your...
Speaking first will be Miss Petty as well as her daughter.
All right, would you state your name, please, ma'am?
Kayla Petty.
And your daughter's name is?
Ava Gutierrez.
Okay. And you can go ahead.
3 years ago, you took, Zachariah Anderson, took a life, Rosalio Gutierrez Jr., or as I and many others would prefer to him as Junior. And by doing so, you affected and ruined the lives of everyone who knew and loved him.
And I'm sorry to do this, but I'm going to interrupt you right off the bat because what you're talking to the defendant. And I understand that's how you prepared, but I probably, ordinarily I would let it go, except there are going to be more speakers and they'll pick up on it. So,
Refrain.
okay, thank you.
It's been 3 years of questions, 3 years of confusion, and 3 years of pain. 3 years ago, exactly 1 week after my daughter's birthday, myself and her stepfather had to tell our 8-year-old daughter that her daddy wasn't coming back, that he wasn't just hurt or just missing, that he was dead. I can still see the look in her eyes and hear her cries. Even with that heartbreaking moment, how do you make an 8-year-old little girl comprehend the meaning of those words? There would be no more daily and frequent phone calls between the two of them. No more weekends together, no more laughter, no more celebrations. He wouldn't be there for her good, bad, or sad days to come. Just like that, he was gone and taken forever. He took away a father of two because of reasons we still can't seem to comprehend. An 8-year-old should not know the cruelty of this world, that there is evil, and that there are monsters out there that do unimaginable things. Zachariah took away an innocence that we can never restore in her. One day, my daughter will be at an age where she knows all the details of the awful things that Zachariah Anderson's done. She will have questions that will go unanswered. Why does she deserve to feel that pain over and over again for the rest of her life? Zachariah has shaped my little girl into a person that he had no right in doing so. He has taken so much from her. Judge, I have watched Zachariah sit there with no emotion and with no remorse. He has not only completely changed my daughter's life and traumatized the people who love Junior, but he has also changed and traumatized his own children's lives. And I hope he takes the time to think about that every moment of every day, how his selfishness and insecurities have impacted the lives of many. I feel this man is a coward, and he is a monster. I wish Zachariah a lifetime in prison to sit there and to think about the evil things he has done and the lives he has ruined. I truly hope it haunts him in the way it haunts us. My daughter didn't ask for this life, but he gave it to her. And I pray one day he will own up to what he has done and that he can find it in him to give us and my little girl the answers that we deserve. My daughter, her brother, Junior's mother, father, family, and friends didn't deserve this. And Junior definitely did not deserve this.
Thank you, ma'am. And did your daughter wish to speak? Okay, thank you.
Judge, next will be Christy Raditz-Ortiz and her child, Julian.
All right. Ms. Raditz-Ortiz?
Almost 3 years ago to the date, my life changed forever. I lost a friend as well as the person who I was raising my son with, his father. Rosalio Gutierrez Jr. took so much pride in that title. He enjoyed nothing more than watching his son grow. They shared so many special moments and memories. Sadly, all that was cut short at the hands of an evil person whose jealousy got the best of him. Because of that, Junior will only live on in our memories and our hearts. This by far was and continues to be one of the hardest things to go through as a mother. My heart aches for my son. Julian will forever feel a piece of him died with his father that day. He contemplated quitting playing baseball because he didn't want to go on without his dad. That was their passion. It's something that they really enjoyed and bonded over. I'm happy to say that Julian decided not to give up, and he's come so far in the last 3 years in all aspects of his life, and we find comfort in knowing that his dad is watching over us. It's just so sad that he can't be there to see it for himself. As much as I'd like Zachariah to suffer the same way that Junior did, I feel a maximum life sentence without parole will suffice. Just knowing that he'll never be able to freely walk outside of the prison walls will bring some peace of mind.
Thank you. Did you wish to speak?
Yes, Your Honor. Thank you for giving me this opportunity to share my thoughts. I want to start with acknowledging that not only me, but every person I love and people that love me were affected by the murder of my dad. Not only me, but my entire family had to go to sleep not knowing where my dad was. Not knowing if he was okay, not knowing what to do, just sitting there feeling anxious, hopeless, and helpless. I didn't want to be happy or even smile knowing that my dad was gone. Just the thought of never getting a hug from my dad again, never saying another word to him, made me sick. Wondering, was he proud of me? Did I say I love you? Did he know that I meant it? I never in a million years thought that when he dropped me off on that evening and we said our goodbyes on Sunday, May 17th, it would be my last time. After thinking about it, I started to find ways to blame myself. What if I spent the night there that night? Would it have changed that monster's mind? I began to feel hatred towards this disgusting, jealous man. And I want nothing more than to have the name Rosalio Gutierrez Jr. to be stuck in his mind and for my dad to haunt him forever. There isn't a day that goes by that I don't think of my dad, about all the good memories we shared on and off the baseball field, all the laughter and all the serious stuff, the life lessons he taught me, the good work ethic he had, and showed me that every day anything was possible. He'd always tell me and my sister that all he was trying to do was make a better life for us and leave us something when he died. After he said that, my sister would say, "No, Dad, I don't want you to die." And he would respond with, "We all have to someday." We just never thought that someday would come so soon. There's a song that I really like, and it says, "It's a shame when people ain't around to see the smiles that they nurture and the laughter that they breed." The fact that my dad won't ever be able to see us grow old and meet his grandchildren, and to have that taken away by one jealous man, is nothing short of a shame. With that said, I believe Zachariah Anderson should be sentenced to the maximum penalty that you can give him. It would make me feel better to know that such a monster can never be free. Thank you.
Thank you, sir.
Speaking next will be Sadie Beecham.
Ms. Beecham?
Life will never be the same for any of us, and I never would have imagined this would have been my life. I've endured some tough losses, deaths of both my parents and a beloved Grams, but no one could have prepared me for this kind of loss. Loss of dignity and self-esteem in a relationship that was manipulative and emotionally abusive, then coming to terms with having to grieve the loss of that relationship, losing the trust and respect of my one and only daughter, my baby girl, the one who made me a mom, due to the irresponsible, inconsiderate, and irreversible actions of her father to exploit her mother and create a narrative of shame to an impressionable 12-year-old girl. Loss of feeling safe and the safety of our children, and the feelings of helplessness and fear with you around. Loss of a budding relationship and a friend who innocently and ultimately suffered the greatest loss, his life. Loss of words when my boys ask if they will be grown-ups when their dad gets out, or when our daughter lashes out in anger and blames herself for those actions, or when she can't sleep at night because of the flashbacks and nightmares that you created, or when I have to talk her off the ledge because she can't take the overwhelming feelings she has as a result of the trauma, or a loss of self-respect when you and your family slander my name, blame me, and lie about me, when those evils are known as well as I do, that sit behind those blue eyes, slick smile, and big words, and yet I continue to allow them the freedom to have a relationship with our kids that they choose not to pursue. A loss is greater than I could ever imagine, but we will continue to survive these losses, and I will continue to choose love and kindness to move forward and to nurture and mother my children with. I will teach them all the good things about you, and I cannot fix the damage you've done, but I can minimize the long-term effects, and I intend to do that with love in my heart every day. You should have just waited for colder weather.
This is meant for Dad. No, I think that's it. 13 letters was the beginning, not realizing that the next 3 years of my life would be taken from me and consumed with learning how to be my own person. Watching myself go into a really dark place was hard. Getting out and regaining my confidence was a whole new level of difficult. I never thought 7 years ago this was the way me, my mom, and my dad's story ended. It breaks my heart to this day knowing things will never be the same. The joy, the sadness, and the anger were all things I once had. And then the numbing happened. And that scared me because it gave me the loss of respect, even for myself. I started thinking and waking up to the fact that now I need to make a change in my life and not let the same abusive patterns continue. Little did I know, I was already trapped. Trapped in a mindset I couldn't free myself from. To this day, I wonder, did he ever love me? Or was I just a pawn, a toy, or his little golden retriever? You took me for granted, and you will never get the same respect back. If you don't believe me, ask Mom. She doesn't have that respect either anymore. After this whole situation, I had to relearn how to not let what other people said get to me so much, and retrain my mind to not have a mindset like my parents. I think you'd like to know it's beautiful outside. It's for sure frisbee weather, and a bit windy. So turbulence would catch it, but we'd have fun. Forever and always I miss you and I love you, but a quote from the 13 letters. Do not come back and expect me to welcome you back in with open arms. You need to work on yourself first. I've worked on myself for the past 3 years. It's your turn now, if you want your baby girl back.
Next will be Eugene Patterson.
Let me first thank you, Your Honor, for allowing me to express the impact of the loss of my son by the hands of Zachariah Anderson. I looked up the word impact, an object colliding with another object, but also influence with the added meaning to push to do or be different. My stepson, Rosalio Gutierrez Jr., Pocho, lived with my wife and I for a time so we could help him get back on his feet as parents will do for their children from time to time. Pocho and I would talk, and the one thing Pocho had a burning need to do was to return to Kenosha, Wisconsin to care and help raise both his daughter and son. I told him that he is doing well in Colorado and should try and make a home for himself in Colorado, visit his children as much as possible, and have them visit him as much as possible. Pocho states, "You are the only father I have had, and if I have learned anything from you, is that you have always been there for your children. My birth father was never there for me. You were, and I want to do the same thing for my children. I want my children to grow up with me in their lives. I want to coach my son as he pursues baseball. Impact. Pocho can no longer coach his son. I want to be there as my daughter pursues dance, and if she is in the future getting married, I want to be there to walk her down the aisle. Impact. Pocho will not be there to cheer his daughter on as she leads cheers on dances. Impact. Pocho will not be able to walk his daughter down the aisle as she continues her life with a person that will become one with her. Zachariah Anderson's life has changed, but he's alive. He will be able to write letters to his family and friends. If his parents and siblings choose to visit him, they can, and they are able to talk to one another. If his children choose to visit him, or his child chooses to visit him, she can. Even though some controls are in place, he and his family will be able to exchange gifts during the holidays if they choose to. Impact. My son Pocho has no choices. Impact. My wife and I can't even visit Pocho's grave, let alone visit him in person. During the holidays, with family and friends, there will be no exchanges of gifts, no exchanges of laughter, no exchanges of hugs, and no exchanges of love with Pocho. What does justice look like for Rosalio Gutierrez Jr., Pocho? His life was taken from him. The person who took Pocho's life should have their life taken with no possibility of parole. Thank you, Your Honor.
Now it'll be Rosalio's mother.
Your Honor, first and foremost, thank you for allowing me the time to address you this afternoon. In my life, I've had many moments which have changed a chosen path in one way or another, but none so life-changing as the day my son was born and the day I learned of his disappearance and death. My first life-changing moment was on Thursday, April 10, 1980, the day of my son's birth. It was such a joyous moment and forever life-changing, for my life was no longer my own. I had a baby boy to take care of and nurture. Each decision and path I took was always geared towards providing him, yes, a humble life, but one full with love, compassion, and a safe home. Many sacrifices were made, including leaving his birth father when he was only 2 years old, to ensure that my son would not be raised he would not be raised with exposure to violence and turmoil in the home. Rather, to be surrounded with love, compassion, understanding, and learning how to treat others with respect. I taught my son these life values early on, which he carried throughout his adult life. Much later, when my son was about 10 or 11 years of age, I introduced him to Eugene, whom I would later marry, much later. Eugene was the father that my son had longed to have, a wonderful husband and stepdad. Both my son and I were blessed when he came into our lives. Over the years, my son felt his dad's love for us both, and as he grew older and wiser, he would share with me, "Mom, if I can be half the man Dad is, I'm going to be okay." Your Honor, my son learned throughout his life from myself and his dad what was expected of a growing man and a father. My son was hardworking, at times holding multiple jobs to provide for his children's needs and expenses. His only goal in life was to be as supportive and present to his young children, showing an interest in their education, their activities, and the plan was to be present for them well into their adulthood, to leave his children some security and a legacy. Pocho had good co-parenting relationships with his children's mothers and their significant others as well. They all worked together, always focused on what was best for the children. Life's second changing moment was on Tuesday, May 19th, 2020, now marked as the worst day of my life and one I will never, ever forget. It was during COVID, and I was working remotely from my home in Colorado, and I received a phone call from my granddaughter's mother that she had just been contacted by law enforcement. She told me that law enforcement had responded to Pocho's apartment for a wellness check and that they were looking for him. Shocked to hear the news, I told her that I would call Pocho and check to see what was going on. I called my son immediately, but the call went straight to voicemail, which in itself was strange. I left a voicemail telling him that I was very worried and to please call me as soon as he heard this message. I then texted him and received no response. My son would always respond to my calls and or texts, especially if I sounded very concerned. He would always call me or text me to notify me that he'd call later. I then immediately proceeded to call his dad and told him that something was very wrong in Kenosha, sharing what I had just been communicated. I still had not received a lot of information, but I knew that we needed to get to Kenosha immediately. I recall receiving many calls and texts as we traveled to Kenosha. It was then that I suspected that something horrible, something so unthinkable had happened to my son. It was a dreadful drive to Kenosha, an anticipation and a sickening feeling of thinking of my boy and what had happened to him. First thing we did when we arrived in Kenosha was to go to our son's apartment. His apartment was taped off with crime scene tape, and a Kenosha police officer was securing the scene. I got out, identified myself, and requested permission from the officer. If I could just walk into the hallway, being granted permission, I did so. My world was shattered. My heart started to race, and I felt this overwhelming feeling of despair and helplessness as I approached my son's front door. I saw blood stains on his apartment front door and walls. The scene etched in my brain, never to forget. I knew then, right then, that my son was gone, dead. I can't explain it. I just knew. All these thoughts started racing through my head. Oh my God, why? Why? My son is dead. I just started to cry, and I was overwhelmed with guilt. I felt, and I feel to this moment, guilt that I had moved away to Colorado and not been there to protect my son. I thought of our last text exchange on Saturday when he texted me a photo of him and the children at the park. I responded with another text, not knowing that it would be my last. To this day, I regret not calling him back and speaking with him and visiting with him on FaceTime. I live with these regrets and so many more. Many days went by when I received a call from Detective Correa that my son's apartment was released. I dreaded it, but I am his mother, and it was my task and responsibility to clean his apartment and pack his belongings. I prayed and found the courage the next day to go to his apartment and begin that heart-wrenching task. I unlocked his front door, blood-stained door, and entered into my hell. I sat on his couch, taking it in, crying uncontrollable, and alone. Alone with my thoughts of despair, imagining the pain my son endured as I witnessed the aftermath of his brutal attack. I gathered myself and started a walkthrough, videotaping and photographing my son's apartment. It would take me days to complete the task of cleaning and packing his personal belongings and his children's too, his furniture. I have it all still, unable to throw away any piece of clothing he wore or item he owned. I will never forget having to scrub off and wipe clean the blood off the entry door, the walls, the ceilings, the blinds, the furniture. My son's blood was all over the front living space, with his blood spatter on his children's drawings and family photographs. While cleaning the kitchen refrigerator, I discovered my son's cell phone, driver's license, and credit cards in the refrigerator freezer. Yet another horror to witness, and the need to call and notify Detective Correa. My only son taken so savagely, with so much rage and hatred. Mr. Anderson did not know my son. My son had children who loved him, who had been with their dad on the days leading to his final days. Mr. Anderson did not care. He did not even care for what would happen to his own children for his monstrous actions and the pain he would cause them and his own family. A few months after my son's murder, our family suffered another loss, my mother. During the ceremony, my grandson asked me if I would be doing anything for his dad. My heart was overwhelmed with sadness and grief for my son and my mother. I had no words for my grandson and barely able to respond that we would. After some planning, we did just that. One day before my son's 41st birthday on Friday, April the 9th, 2021, we got together at the church my son attended. Family, friends, members of the community joined to celebrate the life of my son, Rosalio Gutierrez, Jr. We had no body to grieve over, nor to say our goodbyes. We only had memories, photographs, and a beloved framed Chicago Cubs baseball jersey he owned. Imagine celebrating the life of your only child and not having his body to grieve over. Imagine unable to put closure to his personal affairs because there is no body to obtain a death certificate. Or his children 3 years later with no death benefits for the same reason: no body, no death certificate. We waited a long time, 3 years to be exact, for justice for my son, but it would not have been possible without the countless hours of numerous law enforcement agencies. I thank them all, especially the Kenosha Police Department, Detectives Correa and Anschultz, countless other detectives and officers for their diligent investigations in my son's case. To Judge Gabriel, formerly DDA Gabriel, for initially charging Mr. Anderson, and to District Attorney Mike Gravely and DDA Chris Sedgerick for their presentations of the facts of the case to this court and jurors, for their zealousness for justice and their compassion to our family. Finally, Ms. Heather Beasley for her advocacy and keeping me well informed. We are forever grateful to each one of you. Your Honor, the selfish and monstrous actions Mr. Anderson took Sunday, May 17, 2020, forever altered countless lives. I no longer have the hugs and kisses of my son, his smile, our conversations and visits, watching him grow old and care for his aging parents. His children no longer have the support of their father's presence for their educational needs, life events, birthdays, graduations, weddings, and for their guidance and encouragement in their lives as they grow older. Extended family, friends, and countless others no longer have my son to call on or to share memories with. Mr. Anderson deprived my son of his life, his unfinished dreams and goals he had set for himself. Mr. Anderson deprived my son's life from his children, his family, and his friends. In closing, Your Honor, the emptiness, helpless despair I felt then, I feel today. That's 24/7, 365. It will never cease. For this mother, incapable of moving on from losing her only child. What did he do with my son's body? Will Mr. Anderson ever tell me or tell this court? I beseech this court to consider all the lives forever altered from the actions of one man, Zachariah Joseph Anderson. Mr. Anderson made a conscious, calculated, and planned decisions, which led to the evening hours of Sunday, May 17, 2020. He chose to cowardly stalk my son, consumed with jealousy and hatred towards a man he did not even know, waiting for the right time and savagely attacked and murdered him, then hid his heinous actions by removing and disposing my son's corpse, not allowing my son a Christian burial, now allowing me a son to grieve over, nor a grave to visit. For all these reasons and so many more, I humbly request Your Honor to sentence Mr. Anderson to the maximum sentence of life in prison without the possibility of parole. Thank you, sir.
Thank you, Judge. I don't have to rehash all of the facts of this case. I think all the parties here sat through roughly 17 days worth of testimony, different motion hearings, and everything that went into the prosecution of this case. But I think I'd be remiss in talking about this case without talking about who Mr. Gutierrez Jr. was. And his family and children and mother just did an admirable job of being able to tell you what they've lost, what this has cost them, and who he was. As a prosecutor, I don't get to know who my victims or the victims of the crimes I'm prosecuting are ahead of time. Instead, in cases like this where there's a homicide, we get snapshots. We get the chance to know the victim through the family that's left behind, through the friends that mourn them, and through essentially the evidence that they were able to leave behind, in this case, the phones, the conversations. And what I can say to sum that up is exactly what his family just shared with this court, which was this was someone who was a beloved friend. In talking to different people and prepping this case, they had only great things to say about him. The phrase would give you the shirt off his back was mentioned numerous times. He would do anything for anyone, compassionate, loved his children, so involved, an absolute girl dad for his daughter, would brag about her dance, obviously a baseball coach for his son. And so through these people, I got to know a man that went by so many different names, from Junior to Pocho to Rosalio Gutierrez Jr., and that has been a very powerful experience because he meant so much to so many people, and I'm glad that the court got a little snapshot of that today from the people who knew him and loved him most. When we talk about sentencing, the first thing that we look at is the seriousness of the offense. Here we have 4 different offenses, but obviously the most serious one is the death of Mr. Gutierrez Jr. And the legislature has made it very clear that this is the most serious crime that the state of Wisconsin has and mandates life in prison. Really, the only question is, should Mr. Anderson ever get the opportunity to leave prison? And I think it's pretty clear when we look at the seriousness, the calculated nature, the protection of the public aspect, and Mr. Anderson's only character, that the answer in this case is a resounding no. Mr. Anderson does not deserve to ever live outside of a prison wall. And I say that because this murder was cold, it was calculated, it was planned, and it was carried out on someone who Mr. Anderson didn't even know. He had no reason to hate Mr. Gutierrez Jr., except for the fact that Miss Beecham had elected to move on, and this was her first new relationship. That's what Mr. Gutierrez ended up paying his life for, was for a jealousy for a man that he had no relationship with, would never meet, and never interacted with. When we talk about the facts of this case, and the court heard for a number of different weeks, we have stalking behavior, we have following behavior, we have eavesdropping behavior, we have a lead-up of this defendant essentially prepping, planning, and carrying out this homicide. And the evidence could not have been more clear. Mr. Gutierrez was attacked in his doorway and was hit at least 6 times with a blunt object, at least. And once that was done and Mr. Gutierrez was deceased, his body then was taken from the scene. It wasn't left behind. It was taken from the scene and disposed of in a way that will never give his family closure, because the only person who actually has firsthand knowledge of where Mr. Gutierrez currently is Mr. Anderson, and obviously he's not talking. So the seriousness of this crime, the cold and calculated nature of carrying it out, And the absolute lack of remorse leads us only to the one conclusion, that life in prison without parole is the only appropriate outcome in this case. Another thing the court has to consider is the character of the defendant, and this pre-sentence is incredibly thorough regarding his prior interactions with law enforcement over the last several decades, almost 30 years. And it wasn't the number of convictions or the number of felony convictions that stuck out to me the most. It was his explanation for them. Because everything that this court saw in Mr. Anderson during this trial, in his statements to police, in how he presented this, even in some of the corrections that were made for the pre-sentence investigation, nothing is ever really his fault. The facts are not really what the police say they were or what he pled to. Ultimately, he's essentially always the victim of circumstance, just like this case. And I say that because we talk about even the disorderly conduct, which I know is not an adjudication, but he even took onus with the fact that they charged him with use of a dangerous weapon, indicating there wasn't one. Well, as this court is aware, in order to make some sort of complaint, they obviously have to substantiate it with something. So there's one time where, nope, that's simply wrong. Then we talk about burglary convictions where, oh no, I didn't actually burglarize anything. I simply pled to an offense or was adjudicated delinquent of an offense because my friend took something out of someone's garage and I knew about it. As this court is aware, that is not a way to be adjudicated of a burglary, simply knowing that something has occurred. Then there's another burglary offense where he takes onus with who was apparently with him at the time that it happened, saying that once again, law enforcement got it wrong and his brother, I think was specifically his brother, wasn't present. And then we have the sexual assault adjudication. And this one mattered because once again, it's his own version of events. The victim clearly made the complaint that, well, yes, they were dating and there was some consensual kissing. When he wanted more, she said no, and he forced himself on her. His version is obviously incredibly different. It includes that it was consensual, but also the reason that he was accused of this and ultimately adjudicated for it was because he was so irresistible that he was also trying to date her friend in some way, and so this was a jealousy thing. Not his jealousy, the 15-year-old female victim's jealousy, which led her to make this allegation and ultimately something that he was adjudicated on. And so we see time and time again in the 90s the same type of behavior that we see all the way in 2023. He talks about how he had been a law-abiding citizen for a number of different years. And I think that that's a hard sell for a number of reasons, but one being in 2019 when he's pulled over with 26 pounds of marijuana in South Dakota, transporting it from the West Coast back to Wisconsin, I think it would be naive for anyone in this courtroom to believe that was the first time he ever did anything like that. People don't start with 26 pounds of marijuana transportation. That is something you build up to. That's something that is essentially bad luck that he got caught on this time. But then the telling thing is after that, after being arrested for that, after being prosecuted for that, during the pendency of that, we then had his daughter come in and talk about 72 pot plants that he was growing in his own home. So when we're talking about character, it's someone who's already facing penalties for marijuana, 26 pounds of it, and then is, according to his daughter, cultivating more. And that was backed up by what was found at the house, the seeds, some money, some different things. But it shows a pattern of behavior and the character of the defendant behind that. But Judge, to be honest here, the real clincher in this case in terms of what should be done here is a protection of the public punishment aspect to this crime. Mr. Anderson brutally murdered Mr. Gutierrez Jr. He stalked his ex-girlfriend. He hid Mr. Gutierrez's body. And those are things that need to be punished. They need to be answered for. And I think the public needs to see the swift response of what is the deterrent effect when people get jealousy in their mind. Jealousy is a normal emotion that many people go through, but it's who we are as humans and our character that stops us from crossing a line. And what Mr. Anderson proved during this case is that he did not have the ability to stop his jealousy from costing Mr. Gutierrez Jr. his life. So what I'm asking the court to do is on count 3, sentence him to life imprisonment without the possibility of parole. But then I'm also asking for a symbolic sentence, as obviously that would take him to the end of his life. But I do believe that Miss Beecham deserves her own sentence, because what she was put through, the following, the gaslighting, the terror, everything that she had to suffer because of her stalking, I think deserves its own distinct sentence. So I'm asking that you make a prison sentence consecutive to that life sentence, in honoring the fact that she also was a victim of this, and she also paid dearly in a number of different ways that she indicated to the court. I would also ask that you make the hiding a corpse count also consecutive, because that is a separate and distinct crime. That is a cruelty that almost goes beyond even what the murder was, because a family is left to grieve, but to never really know. To never really know where their loved one is, where his final resting place is, and that's something that they likely will never know, because the one person who has any idea obviously isn't going to share it. So for all of those reasons, I do believe life in prison without the possibility of parole is the only sentence to render here, and I would ask for those consecutive prison sentences in recognition for what those counts are, separate and distinct from the homicide of Mr. Gutierrez Jr. For sentencing purposes, I believe there is 1,092 days worth of credit, not counting today. I would also ask for a restitution hearing to be set, as I know that some documentation is still pending regarding some of those requests, and I believe that that would be appropriate so that parties can have all of the documentation before making a formal request. Thank you.
Thank you, Judge. We have people on behalf of the defense that would like to speak as well. I'd like them to go first before. Right now, I want to confirm, but I know for sure that it will be Mr. Solomon Anderson. That's the brother of Mr. Anderson. I'm not sure if there's anyone else who'd like to speak. I obviously have been sitting here at council table, have not been able to confer with them, but if my paralegal may so do so shortly, just ask briefly and ask that the court give leave for us to be able to do that.
Permitted to speak by law or so closely impacted by the case that special attention should be paid to their thoughts. For example, a good connection would be a firefighter or police officer whose life is lost, and some of that individual's comrades would be permitted. But as a general statement, I don't permit statements by other than the attorney and the defendant.
Judge, the defense would maintain the position that Mr. Anderson's family members have been affected as well by this case, will be affected by the sentencing. If the court would permit, just to allow Mr. Solomon Anderson to provide a brief statement, I think it's important for this court to hear from people who have known Mr. Anderson for the majority of his life about his character, because naturally that's not evidence that can come in during a trial, and I think it's important for the court to consider the character from the perspective of the defendant, and the defense believes that there's no one better to do that than Mr. Anderson's own family members. So I'd ask the court to allow the defendant to present one individual to speak on his behalf.
I don't see a letter from him, so he could have offered one of these letters and had it come in more timely. Had there been one, I would have reviewed his thoughts, but I'm not seeing. There's one from someone who identifies.
There's one from Zenith Anderson, who is Mr. Anderson's sister. Judge, respectfully, the defense was not notified that we would not be able to have people speak.
I don't know why you would think that I can't remember when I ever did. And
and that's fine. That's
I've
fine.
been here
It's
40
just,
years, and so I'm going to say no.
Okay. Well, then I will speak at length of Mr. Anderson's character as I know it. As over the last 3 years, I've gotten to know a very different side of Mr. Anderson than which was presented during the trial in this case. It's very easy to point out the negative characteristics of someone and to address the negative characteristics of an individual when that's all that's been presented. As the court's well aware, there are numerous rules of evidence that prevent certain types of things from coming in at a trial. Things that show the good side of Mr. Anderson, the good memories that people have, and the positive things in his life.
You know, I don't want to unnecessarily elongate this, but I have made exceptions. When someone offers me something about, well, 2 years ago he was walking down the street and there was a building that was on fire, and at risk of his own life he went in and rescued a whole family. That's something I would certainly want to hear about, and that would be different. But here, the first letter he gave me, she's telling me her passions in life are music and animals. I have too many dogs. I have a wonderful cat, a gorgeous buckskin quarter horse. The things I love most in this world are my son, my family, friends, and chocolate cake. That isn't going to help me.
Sure, Judge,
If you've got something of the type I mentioned that is especially commendable in the defendant's character, I certainly would welcome that. But just a general character endorsement by his brother would not generally have significance in the decision I have to make.
And I understand that, Judge. I wasn't speaking about Mr. Solomon Anderson. I wasn't trying to offer what Mr. Solomon Anderson would say. I was simply just presenting the defense's position on sentencing.
She's making her argument at this point.
Well, that I understand, but the way it began was following up on the discussion we had before. So I certainly don't mean to cut you off.
I think it's important, and just to premise, because I do felt cut off, and I do feel like the court does not want to hear about Mr. Anderson's character as we see it and as I'm allowed to present it. But I would like to continue on talking about Mr. Anderson. This is the sentencing for Mr. Anderson, as the Supreme Court in this state has made it very clear that pursuant to Gallion and McCleary, that a sentence, regardless of what the crime is, has to be individualized, has to be for the man who is sitting to the left of me. And if I can't speak to who that man is, I don't think this court can sentence him pursuant to that. If I can continue, I would really appreciate that, Judge.
If any of my remarks suggested I did not want to hear what you have to say, I apologize for that. I don't think they did. I think I was finishing the discussion about authoring statements of others, but go ahead. I'm sorry.
Thank you, Judge. As I was saying, it's quite easy to focus on the negative aspect of someone when that's all that's been introduced. Mr. Anderson is a father, is a brother, is a son, and his entire life he has maintained those roles and has executed them. He has many good memories, and some of those memories were shared by others on the other side and in the letters that were provided to this court that I know the court had to review. memories such as not cutting his hair until his daughter could cut his hair, teaching his daughter how to skateboard, being a supportive figure in not only his family's lives, but his friends as well. That was reflected in there. The state went at length to talk about how Mr. Anderson's prior record is indicative of his character and his denial and way to push off responsibility, and I don't think that's accurate. The latest offense that seemed to have gone unnoticed as far as accepting responsibility is the South Dakota case. There was never any thwart to responsibility. There was never any denial in that case. Mr. Anderson took a plea, and that was that. As far as the state's assertions as it relates to the 1994 disorderly conduct use of dangerous weapon, the defense would maintain that the court should not consider that. One, there's really not any information on what that was. The PSI writer even said, I can't gather any information on what happened here because no record exists. So I don't think it's appropriate for the state to assert, oh, he's had a dangerous weapon and denied it, when there's no proof of what actually occurred in the 1994 case. Not to mention, there was no finding of delinquency in that matter. In fact, when we look at Mr. Anderson's record, there's really nothing there comparable to why Mr. Anderson sits in front of you today. There's no history, no convictions of violence. That's not shown because that wasn't and isn't Mr. Anderson's character, despite the verdict in this case. The defense sits before you in an extremely uncomfortable position. We have a situation here, Judge, where the defendant maintains his innocence, yet we have a verdict. We have facts. The defendant at no point wants to discredit how individuals, family members of Mr. Gutierrez feels. I don't think there's any dispute that no one's heard from him, no one's seen him. And we would sit here in front of you and say that for those who, relating to Mr. Gutierrez, sit there and feel that they have some sort of guilt. Julian, his son, had noted that he felt guilty because he should have stayed, that none of them should feel that way. We have the verdict, but we also have laws that are in place. Specifically, Wisconsin Statute 973-014, which allows this court to determine a date in the future where Mr. Anderson could be eligible for extended supervision. Naturally, the state in this case is asking that the court deny that opportunity. Several individuals who spoke on behalf of Mr. Gutierrez and those who were directly part of Mr. Gutierrez's life asked for the same. But I think we also need to look at the fact that even though the legislature enacted the mandatory minimum in this case, that being life, they also enacted this statute. And they did that because they recognize that there are things that can happen where an individual should be able to return back to society. And we have that because as a country, as a collective people, our inherent nature is not to be barbaric, is not to put people away for the rest of their lives. We want people to be able to return and contribute in a positive way to society. That's why we have the correctional system. So the defense would be asking that the court consider setting a release eligibility date in this case, and it can obviously be as far out as the court would want. The defense would be asking that it be set for after a 25-year period. Thank you.
Thank you, Ms.
And sorry, Judge, sorry to interrupt. I believe the state had said 1,092 days for sentence credit. That is the calculation that the defense has as well.
Thank you.
Yep.
All right, Mr. Anderson, is there anything you wish to say before sentence is pronounced?
How much time do I got?
Well, I'm going to talk about that a little bit. Oh, you mean how much? Oh, I misunderstood. I've had people give a slightly
we're not
different version
not
of
that version. Yeah.
How much time do you have to talk?
Yeah.
Yeah, I'll give you a reasonable period. I mean, this is one of the major events of your life, so you're certainly welcome to speak. I'm not going to say it's unlimited, but you're welcome to tell me what you think. Speak from your heart.
I don't want to go into all the details of the case. I got a lot of dispute about what was said, what was portrayed. I think the facts, with a little more scrutiny, tell a much different story than what the jury decided, and I don't think that things played out fairly. I think that there's some things that are not just from our side, questions outstanding for both sides, and I don't think the court accomplished what it set out to do in any means if both sides are left with so many questions. And I don't think, without going into the case, I don't think we really got to the heart of the matter. What I can tell you is I didn't kill anybody. What I can tell you is I didn't stalk anybody. And what I can tell you is I didn't dispose of any corpse. It's really weird to be sentenced for or convicted for it and soon to be sentenced for it, but I didn't, Judge. Kind of feels like there's no turning around on that now. I don't really know how to make a better statement of my opposition. But I disagree. I'm innocent. I don't know what you're going to decide. I don't know what you're all going to weigh. I don't even know how to represent my own character without having my family be able to testify on my behalf. But they do have some things that are relevant. I mean, even during the trial, there was a gentleman who tried to come up and talk to me. I think there was a comment about how now everything has happened during the trial. When he made that attempt, nobody really knew who he was, and I do know who he is. He's a man who I saved from assault in jail. He's actually related to one of the jailers, and my heart went out to him because I know he appeared inebriated, and I know he struggles. And I know he was coming up here to talk to me because we got along so good. But those tiny little moments throughout somebody's life, nobody accounts for those. But what they do a really good job of is making up all of these things that they want you to believe when they can label you as a monster. I still didn't. It's still weird. I want to be remorseful, and I am for the things that I did wrong. You're welcome to sentence me for everything that I did wrong, just like the judge in South Dakota. The only thing that I disputed in that instance was whether or not I was coming back to Wisconsin with that, which the prosecution has now repeatedly made false statements about on their own assumptions, hoping that everybody in this courtroom, everybody that's watching this, would buy, oh yeah, he was bringing something back to Wisconsin. Not true. Was I caught with marijuana in my car? Yeah. Yeah, I was. Should I have? No. Did I bend the rules there? Broke them. Broke the rules. And when they said, hey, this is a problem, I said, well, I did knowingly, and I'll be held accountable for it. That's it. And if I killed somebody, whatever that situation was, I can tell you in my own heart it wouldn't be intentional. But if I didn't at all, a guy I never met, I don't really know what this is, but I didn't do it. I'm innocent, Judge. Not guilty. I'm innocent. That's all.
Thank you. When I came out of law school and took my first job right here in Kenosha as an assistant district attorney. The statutory penalty for what the equivalent of this crime, murder of the first degree, was life imprisonment, as it is today. And before an individual was eligible for parole, 13 years plus, I think, 3 months, something like that, had to be served. And only at that time could the individual apply for a parole. And not a lot of people got paroled at that time. Over the next period of years, maybe within 10 years, the legislature had, as I recollect, and I think at the behest of the Department of Corrections, had reduced that minimum parole period to around 11 years. And they had it down to around 9 when the law started to change, and the legislature passed a law under the sponsorship of Senator Joseph Andrea from Kenosha that became known as the Life Means Life law, and it didn't provide exactly what it does now for absolute denial of eligibility for parole, but it did allow the judge to fix the minimum period to be served before a person convicted could be eligible for a parole. And then ultimately the legislature made further modifications to the point that the court now has the authority to deny eligibility for release altogether. It's interesting, the statutory penalty has never changed. Life imprisonment. But the eligibility for release has changed very dramatically. And of course that means not that you get paroled, but you could apply for a release to extended supervision. The price for intentional homicide in this degree remains the same, life imprisonment. And every life is the same. These people have come here and expressed their very touching, moving sentiments about this person whom they loved. And that all is permitted for them to do because they're the victims and they've suffered a loss without any contribution on their part or that of Mr. Gutierrez. They've suffered a loss, which the jury has found, as was their power, to have been caused by you. So they're entitled not only to express their mourning condition, but also to focus on what the text of the law actually says and ask that you be sentenced to life imprisonment. But the legislature, although it could do so, has never provided that life means life in those explicit terms, except in some cases where the judge cuts it off And in a very high percentage of the cases, I do deny eligibility for extended supervision. But it's not every case, and every case has to be looked at separately, as your lawyer has pointed out. But like physicians at the hospital, when they have people brought in from a shooting incident, are not permitted to discriminate on the basis of age or sex or religion, or even maybe a police officer who's shot, and the guy who shot him. The physicians are trained and are ethically bound to treat people in order so as to preserve life. They're not allowed to treat the less seriously injured and let they're not allowed to treat the less seriously injured police officer before they treat the person who shot him. It's at the core of our beliefs about the value of human life. And it is expected, and it should be the same for judges. Every life is to be given the same degree of respect by the law. And when it is ended criminally, as has occurred in this case, every life that's lost should be valued the same. So when you read about these frightening statistics about the killing rate in some of our major cities, and unfortunately even here, the legislature still has not given us the command that every case's life means life. They've provided that a number of factors have to be considered. And those are what your lawyer referred to as the Galleon factors. One of them is not that you're a bad person. I'm not commenting at all on the type of person you are, because it's not part of the equation. What you did was frightening, horrible. And you can wag your head all you want. The jury found beyond a reasonable doubt that you did it. And so the loss of these people is beyond measure. But it is important that they realize that I have this litany of factors that I must consider, and that what ultimately is the sentence that you receive is not the measure of the value of Mr. Gutierrez's life. That's if the law is what it is, then, and the judge considers those factors and doesn't impose a life without parole sentence, the family, while I certainly don't expect them to agree with the outcome, should not take that as a comment by the law or by me or by the legislature or by the jury that Mr. Gutierrez's life wasn't as sacred as they believe it was. The Department of Corrections has a policy of the reduction of sentences. They've got, well, the best, clearest example I can think of is people who are convicted of seventh offense, driving under the influence, and who are required, I think, the law is minimum 3 years. I think that's still current. The judge was required by law to impose that sentence, minimum 3 years. The Department of Corrections was releasing people in big numbers after 7 months because they had come up with some treatment program that they thought was effective enough that 7 months would be an adequate period to serve. So they broke the law repeatedly and released people at 7 months until the Court of Appeal, a couple of judges from Milwaukee caught them on it, and the Court of Appeals put a stop to it. The current administration is committed to reducing the prison population by 50%, and there are more and more programs being pushed into the courts all the time to facilitate the reduction of our sentences. And I just heard about another one today that we're going to be a pilot project for, where the drug courts, which have been originally, we were told were going to be very selective about who got in and who got much more modest outcomes. Now Kenosha is going to be part of a pilot project, and as I understand it, every single offense is going to be reviewed for the drug court. So it's, without commenting further, I'll just say there is a very large effort being made to let people out of prison, or not let them in the first place. And why am I bringing this up now? It's because any sentence that I give you, well, not any sentence, but just about any sentence, is going to last long enough that you will be an old man before you would be considered, even if I do make you eligible for extended supervision. And the last thing the Department of Corrections seems to want is old people in prison, because they're expensive to care for them. There was a reference to the sentence that you deserve. And I understand why people would say that. And I can't say, I don't say it myself when I see about some of these crimes that are portrayed on television. But I don't like to get involved with what people deserve. That's a kind of a frightening concept to base a sentence system on. Actually, the reason we have the criminal justice system in the form we have it, where the sentence is imposed by someone who is neutral, is to reduce violence. Because if we didn't have this system, people would take it upon themselves to give people what they deserve. And I'm afraid in the era in which we live, with the way things are being handled in the criminal courts, we're going to see more and more incidents that will be branded as vigilantism, which are merely reflective of what people will turn to when they don't feel justice is done through the courts. So that's a factor that has to be considered, is the sentence has to address the enormity of the crime. I was very, very moved by the testimony or the remarks today by the lives that were touched by your vicious criminal act. And I wondered, to what extent did this man even think about these things? Was he so wrapped up in himself that it didn't even matter to him the effect it would have on the people who loved him? So if I got into the issue of deserve, that would certainly be at the forefront. I will say that you have been cooperative throughout these proceedings. You did not contaminate this courtroom by giving perjured testimony, which a very large share of our offenders do. The degree of planning of the crime and the concealment is very concerning, and speak to long-term determination of lawless behavior. On the first count of the information, it is the sentence of the court that your custody be committed to the Department of Corrections for a period of 2 years, followed by a 2-year period of extended supervision. On the second count, for an identical sentence to be served consecutively. On the fourth count of the information, hiding a corpse, for a period of 6 years of initial confinement, followed by 5 years of extended supervision, to be served consecutively to counts 1 and 2. And on the third count of the information, it is the sentence of the court that your custody be committed to the Department of Corrections for confinement in the Wisconsin State Prisons for the remainder of your life. This sentence is consecutive to and not concurrent with the sentences on the other 3 counts. The period of eligibility for extended supervision will not occur until 40 years following the date upon which you start the sentence on count 3. You have rights of appeal with respect to the disposition of this case, and your attorney will review them with you. If you understand your rights, tell Ms. Muller she'll have you sign a document acknowledging that. If you don't understand, tell her she'll bring you back in here for further instruction. There's a copy for you as well. Persons convicted of felony, as you have been, are ineligible to have firearms in their possession. That is a lifetime prohibition, and unless you have a permit from the Secretary of the Treasury, you may not have a firearm in your possession at any time for the duration of your life. It is a serious state and federal crime for you to do so. There is credit to be allowed for 1,092 days in custody to be applied to the sentence in the sequence 1, 2, 4, and 3. All sentences, as I think I indicated, are to be served consecutively to one another. The conditions of its extended supervision, I think I'm actually going to withhold any action on that on the supposition that there will be no extended supervision until he's 95 or thereabouts. And they can best be addressed. Well,
They're going to ask.
you know what? I think you're right. Although I did do one and it didn't, and it hasn't come back yet. You'll abide by all rules and regulations established for you by your supervising agent, pay the costs and disbursements of this action, repay to the, that one, no. The matter of restitution is to be referred for examination by court commissioner and return to the court with recommendation within 60 days. You're not to have a firearm. I did that already. No contact with any member of the those who are statutory victims in this case, except as is allowed by your supervising agent. Any other conditions requested? No, thank you. Anything else?
Judge, as far as the, I just want clarification on the no contact with those considered to be victims. I know that OA has been categorized in that way in this case, and naturally, I guess the clarification that I want is that was the no contact that was just discussed had to deal with if the individual was released, that would be a condition of the release. But while in custody, is there going to be a no contact order issued?
I'm not aware that I have the authority to issue any order on that.
And I would agree, Judge. I just wanted that to be clear on the record.
I'm not imposing any order on that. I think that's a determination to be made by the Department of Corrections. Do you disagree?
Well, I think you do have the ability to make that order because there is a crime for contact after conviction, violating a court order. But my understanding is OA is not requesting for a no contact.
I've had a chance to speak to her in court.
Okay.
She's not requesting that.
Okay. I'll leave it as is then. Anything else?
Yes, Judge, one last thing. A proposed order was submitted to the court on behalf of Mrs. Patterson regarding this court, given the verdict by the jury, ordering the medical examiner's office in Kenosha County to produce a death certificate.
I got a letter. I don't recall seeing a proposed order.
It accompanied the letter. So the letter came through and the order came through directly after it. I think it was end of April, April 20th. Yeah, it came through a letter to Attorney Capri.
Right.
Judge, I would ask that that be taken up at the restitution hearing. I think that's a more appropriate time to address that.
Well, I don't know why, because the commissioner is making a referral only to examine the circumstances regarding restitution. I had the trial here, and the fact of the death of Mr. Gutierrez was an essential ingredient of the conviction, and so nothing the commissioner can report can change that fact. But I was on vacation last week, so I got that just before I left, and I did not see the proposed order.
I did not see a proposed order. I see the letter,
And I did when I got the letter, and I was. He refers to a. No, I don't even know if it does. I did not see a proposed order, and I did do a little bit of checking. And I will tell you, is there a statutory process for this? And I, frankly, my intention was to start by calling the registrar and ask if they have a procedure that they would like followed on this, and if statutorily compliant, follow that procedure. If they don't, then
I guess, Judge, where the defense thought that it would be more appropriate for a different venue to hear that is it is a civil determination. I too was trying to do some research on it, granted my young age, and in the homicide cases that I've worked with Attorney Birdsall and Attorney Aubert, and on my own, I've never seen that determination for that purpose be done by the criminal court. It's always been a separate civil proceeding. So I wasn't able to complete or find definitive answers in my legal research, but my position, just based on the type of finding and why it's going to be used for, is a civil finding that I don't think should come from the criminal court proceeding over the criminal case. I think it should be a different court and make an own separate finding based on the finding in this court of the declaration of death.
Well, I don't know. I do know that the conviction on the third count requires a proof of the death of Mr. Gutierrez and at the highest burden of proof. So I don't think I don't have any conceptual disagreement with this court making such an order, but I'm going to ask that you confer with Mr. Cafferty, Ms. Krasaric, and also with the registrar to see if they have a form order that they would like to have, because as Mr. Gravely has so aptly pointed out, talking about the restitution or the extended supervision, it'll come back. So let's see if we can get it right the first time. So I'm not going to do anything at this point, but if you can report to me what you find out, and to Ms. Muller.
Thank you, Judge. I appreciate that.
Okay.
I do have CR 233, the Notice of Right to Seek Post-Conviction Relief Form. Perfect.
Okay. Thank you.
Actually,
So all four counts were consecutive, correct?
Each consecutive to the other.
Can our people be excused?
I think you're going to be with him for a bit? Yeah, yes. I'm going to ask folks if you'd be kind enough. No. Let me ask that those on this, my left side here that I'm pointing at, if you'd step out and leave the building. I'm not commanding that you leave the building, but I'm encouraging you to do so to avoid any problems. Okay? And thank you. And then when they have gone, then I'll ask that you folks leave. And thank you all.